All right, let's dive right in. Today we are talking about the absolute foundation of one of the most powerful tools in common law, the trust. We're going to break down what a court actually looks for to decide if a trust is the real deal or if it's just an empty promise. So let's start with a classic problem. Imagine you want to set money aside for your kids. Great, but you're worried they're going to blow it all the minute they turn 18. Now, if you just hand over the cash, it's theirs. Game over. Your wishes mean nothing in the eyes of the law. This exact puzzle is why the trust was invented. So what is a trust, really? It's so important to get this right. It's not a company. It's not a secret bank account. At its very heart, a trust is a legal relationship. It's a relationship built on a very serious duty, and it has three main players: the person who creates it, the person who manages the stuff, and the person who gets to enjoy it. Okay, so the settlor puts the assets in. The trustee holds and manages them. But, and this is the absolute key to the whole thing, the trustee has a rock-solid legal duty to act only for the benefit of the beneficiary. This isn't a friendly suggestion. It is an obligation that can be enforced in court. If the trustee messes up, the beneficiary can sue. And this setup creates a really powerful separation. When you do it right, the trust assets are no longer legally part of the settlor's personal wealth. That's huge for asset protection. But because it's so powerful, you can bet the courts have a super strict checklist to make sure everything is legitimate. And that checklist is famously known as the three certainties. I want you to think of it like a gauntlet. To be recognized by the law, any express trust has to pass through these three gates: certainty of intention, certainty of subject matter, and certainty of objects. Let's break down each one. First up, certainty of intention. The big question here is, did the person who set this up actually mean to create a legally binding duty, or were they just, expressing a hope or a wish? Now, the courts aren't mind readers. They don't care what the settlor was secretly thinking. As we saw confirmed in the case Guy Neal v. 9 Squares, the test is objective. They look at the evidence, the words, the documents, the actions, and they ask, what would a reasonable person conclude was meant here? And this is where we see a very fine line between what lawyers call precatory words, words of hope like I wish or I desire, and words that actually create a command. Just saying you wish something would happen is almost never enough. But it gets tricky. Like in the Comiskey case, the phrase was in full confidence, which sounds soft, but the court looked at the entire document and found that the overall structure actually created a binding obligation. So context is everything. And get this, you don't even have to use the word trust at all. There's a famous case, Paul v. Constance, where a man put money into a bank account that was only in his name. But he repeatedly told his partner, the money is as much yours as mine. Well, based on his words and their actions, the court said, yep, that's a trust. The substance of what he did mattered way more than the legal label. Okay, on to our second test, certainty of subject matter. This one sounds simple. The court has to be able to identify the specific property that's actually in the trust. No ambiguity allowed. If the language is too fuzzy, the trust just fails. In one classic case, a trust for the bulk of my estate was a no-go. I mean, what does bulk even mean? Is that 51%, 90%? Who knows? But here's an interesting contrast. A trust to provide a reasonable income actually succeeded. And you might ask why? Because a court can work that out. It can look at the beneficiary's life and put an objective number on what's reasonable. This all gets a bit more complicated with modern assets. The old school view was that you had to be able to point to the specific thing, this gold bar, not just any gold bar. But what about shares in a company? They're identical, they're interchangeable. Well, the law evolved. A huge case called Hunter v. Moss decided that for assets like that, you don't need to segregate the specific ones, saying 50 of my 950 shares is clear enough. And this shows just how the law keeps up. For a long time, nobody was sure if you could hold cryptocurrency in a trust. But then, in 2023, the Singapore High Court in the Bybit fintech case just came out and said it. Yes, crypto is a form of property, and it can absolutely be held in a trust. The assets change, but the legal principles adapt. So we have a clear intention, and we have definite property. The final gate we have to pass through is certainty of objects. Put simply, who is this trust for? The beneficiaries have to be identifiable. The specific test here actually depends on the type of trust. If you have a fixed trust, say $1 million to be split equally among my business partners, you have to be able to write down a complete list of every single partner. But for a more flexible, discretionary trust, say my trustee can distribute money among my former employees as they see fit, the test is different. The trustee just needs to be able to look at any person in the world and say with certainty, yes, they are a former employee, or no, they are not. So we've gone through the three certainties, but underneath all of them is one single fundamental rule that explains why they even exist. It's called the beneficiary principle, and it is the real engine of a valid trust. And it was all summed up perfectly in a case from way back in 1804. For a trust to work, there must be somebody in whose favor the court can decree performance. In other words, there has to be a person who can show up in court and force the trustee to do their job. If there's no enforcer, there's no trust. This is what was so brilliantly described in the case Armitage v. Nurse as the irreducible core of obligations. You just can't have a trust without this core duty owed by a trustee to a beneficiary, and that beneficiary has to have the right to enforce it. If you try to write that out of the deal, the whole thing collapses. And that's exactly why trusts for some abstract purpose usually fail. A trust for promoting family unity sounds lovely, but who's going to sue if the family isn't feeling united enough? A court can't measure that. But a trust for my children, Alice and Bob, well, you better believe Alice and Bob can walk into court and hold that trustee to account. Now, the big exception to all this is, of course, charitable trusts. They don't have specific beneficiaries you can list, but they don't break the rule because they have a different enforcer, the Attorney General, who steps in to act on behalf of the public interest. So, you see, the need for an enforcer is still there. So when you boil it all down, the incredible power of a trust doesn't come from good intentions. It comes from its rigid, legally enforceable structure. The three certainties aren't just technicalities. They're the tests that prove a simple wish has been turned into a command the law will actually back up. And that leaves us with a pretty important question for anyone planning their affairs. Have you translated your wishes into enforceable rules?